RRAR events. We are recording this, so get that out of the way. Hopefully you were able to take note of the other upcoming events and classes. Feel free to reach out if you ever need assistance with anything in registering. As mentioned, we have about 100 on the Zoom call, so we're going to record this, but please stay muted unless you are speaking. There's definitely going to be opportunities to ask questions. We are excited to have John Waite with us today to answer all of your burning questions on all of the forms change updates. John Waite joined the North Carolina Realtors legal team in 2015, and he previously worked solo at his own firm and clerked for several judges at North Carolina Court of Appeals. When he is not answering hotline questions, he focuses on litigation at Martin and Gifford and enjoys playing soccer, mountain biking, road cycling, triathlons, and spending time with his family. Thank you for being with us, John. We are going to dive right in, and I will turn it over to you.
Sounds good. Appreciate it. That was a very nice intro. Although, I wrote that bio myself, and the last one is not quite correct. I don't love spending time with family. I'm not sure anyone does. But anyway, I mean, I love them, but that's just a completely separate question. Anyway, thank you all for being here. Let's go through these form changes. I'm going to give you a little preview of what we're going to go through today. There's quite a few forms changes to the residential forms this year. And so what we're going to go over today is 2T, a small part of 12T. So 2T is the offer to purchase. 12T is the vacant land offer to purchase. And then we're going to go over 2A7, which is the buyer possession form, although there will be a lot of bleed over into the seller possession form. Those edits will substantially be the same. So we'll talk about those two. We're going to talk about 4T, which is the amendment. And then we're going to talk about the exclusive listing agreement, form 101, and talk about similar changes to form 201, which is the buyer agency agreement. And then finally, we will do form 780. Okay. So that's what we're going to go through today. I expect to keep it less than an hour, and to give you plenty of time for Q&A, but there is quite a bit of stuff to go through. So let's get right to it. I'm going to share my screen with you guys. And this is the most important part of the presentation today by far. If you pay attention to this part, then you can actually tune out the rest of the time, I think. But anyway, we wouldn't encourage that. But if you wanted to, you could. So this is ncrealtors.org. This is our main website. If you go up here to this upper part, you can see a little dot that says Q&A, and that's the page that we're on right here. If you scroll down, there's a little dot for forms. So it looks like this, and you click it out. And this will give you the summary of the forms changes for the last couple of years. Today, we're going to go through the residential forms change, which is right here. And if you click on that button, then what you get is this. I apologize. I need to, let's see if I can hide this thing. Yes. Or not. Hold on a minute. I'm trying to get something out of the way on my end. There we go. Got it. So if you click on summary of residential forms changes, it brings you up this handy dandy PDF. And what this PDF does is it goes through and gives you bullet point explanations for every single one of these changes. It also has a hyperlink, which is what we're going to be going through. And that hyperlink will take you to a marked up version of that form. So when you click on that hyperlink for form 2T, this is what comes up. It shows you all the strike throughs. It shows you all the highlights. You can really get into the granular detail of what exactly is going on. Okay. So let's go ahead and start with form 2T. And kind of go through this. I'm going to go through the actual forms themselves. Me personally, I just find that to be a little bit easier to go through than the bullet points. And also it's a little less abstract. So that's how I'm going to go through it today, but feel free to follow along on your own, just in the PDF with the bullet points if you like. So form 2T at the beginning here, instead of this note that used to be here, now there's going to be an affirmative checkbox of whether there is or is not going to be a mobile home as part of the transaction. And the reason for the reason this was put in is because too many times this was not being alerted to the closing attorney. The fact that it's a mobile home that's not fixed to the property comes up at the very end, and then threatens to disrupt the entire transaction, and sometimes does. So the reason this was changed is to make sure that this is alerted to at the beginning. Now, it doesn't really matter, if it's definitely, if the mobile home is affixed to the land, go ahead and still check this box. So it doesn't matter whether it's personal property or not. This is at least going to alert the closing attorney that, hey, you need to check into this a little bit more. Okay. And if there's going to be a manufactured home, then consider putting 2A11-T that has information that has to do with it's the existing language that already is in the additional provisions addendum for manufactured homes. All right. So we got a date here, basically taken out by the effective date for payment of the earnest money deposit. Now it's just within 5 days. So understand that's, I mean, you can get it on the effective date. And I guess if the seller still wanted to, not put their signature on it until the earnest money was definitely in the hands of whoever the escrow agent is, then they can certainly do that. But otherwise, the default is going to be 5 days within 5 days of the effective date. Notice that the due diligence fee remains the same. Due diligence fee is still due on the effective date. All right. And sometimes with these small ones here, I'm just going to keep moving because we have too many big fish to fry today. I'm not going to spend time on the small fish. But while I'm skipping past that, just so you know, and I'll give you this information, write it down if you have the ability. Another thing another resource is available to all of you as realtors is the legal hotline. And you can reach the legal hotline several ways. The first is you can call the hotline phone number and actually talk to me or one of my 3 partners. We actually just added a new guy last week to help us out with the hotline. His name is Adam Stallings. And so it's Will Martin, Bill Gifford, me, John Waite, and Adam Stallings. If you call the hotline, you'll talk to one of us. You will definitely talk to a lawyer because we don't have any paralegals for you to talk to. So even if you want to talk to a paralegal, it's not possible. Anyway, that phone number is 336-714-0332. And you can also get there through the main office in Greensboro. So if you call the NC Realtors line in Greensboro, if you forget that number, you can call that number and they will reroute you. The other way you can contact the hotline is legal hotline at NC Realtors. That's with an S.org. So legal hotline at ncrealtors.org. If you're not already using that service, you definitely should. One of the most common things we do on the hotline is go through and walk through people with the forms and how to fill them out. So right here, we're in paragraph 2. This is paragraph 2B in particular. And while we're here, this isn't the forms change, but this is something I have to talk about a lot in the hotline. So I might as well bring it up while I'm here. Don't forget 2A is right here. And 2A is an important paragraph because what it says is that all existing fixtures are included. So just because something is not down here in the bullet points, which by the way, not everything in these bullet points is a fixture. For example, a garage door opener, not a fixture. Okay, it's just a little device that'll open the garage door. But what paragraph B does is designate these things that are in the bullet points here, designates them as fixtures that are going to convey, even though technically they probably fit into more of a gray area rather than a straight fixture. But I just had a question on the hotline on Monday where there was apparently, and I don't know why, I didn't get the context, but apparently there was a ceiling fan that was in a tree. And it was very important to the buyer that this ceiling fan in the tree continued to remain there, and the seller took it. So the question is, was the ceiling fan in a tree, even was it a ceiling fan if it was in a tree? The tree fan, we'll call it the tree fan. Is this something that should have conveyed? Should the buyer have got it? And the answer is yes, I think, based on 2A. I think there's a good argument to be made. Now, whether a judge is going to say a fan in a tree is a fixture, that's a really interesting question. They'd have to go through an analysis on that. But I wrote a Q&A last year about inflatable hot tubs, and actually that got fixed here, so that Q&A isn't on the website anymore. But I'm going to do another one that goes through the common law analysis of how do you determine whether something is a fixture or not, and that really goes to paragraph 2A. So anyway, I'll be releasing another Q&A on that to replace the old ones. Don't worry. But so a couple of things in these bullet points while we're here. Number one, fuel tanks has been moved. So we're going to get to that, and it's just been deleted out of this. And the second thing is that, as I just mentioned, inflatable pools, spas, and hot tubs are excluded. I think that there was the previous Q&A, there's a pretty good argument to make, I think, in certain situations that the inflatable hot tub either should or shouldn't stay. Sometimes I think it'd be possible under our common law analysis where it would stay if you built a lot of special things around an inflatable hot tub. But that's been changed now to make sure it's clear, if there's an inflatable pool tub, they better put it down here in this personal property paragraphs, or else, the inflatable tub or pool is not going to convey. All right. And a change here to go along with the new fuel tanks paragraph, any leased fuel tank shall not convey. So that's one thing that hopefully that'll prevent some problems that agents have been having when they forget to put that in there and then they get up to closing. It doesn't happen all the time. I think most of you guys are pretty good about it, but there were some issues where we get up to closing and then find out that the seller actually leases the tank instead of owns the tank, and then there was some conflict with that bullet point. All right. This is clarifying this note, just rewording it a little bit to emphasize that there's no loan or appraisal contingency in this offer to purchase a contract. And depending on whether you're attaching an appraisal addendum or not, perhaps there would be some alteration to this, but what this is doing is just alerting the buyer and seller that as far as the standard form contract is concerned, then there is not one. Okay. Keep going. Fuel tank out there. So this is to emphasize, I don't think this is a change from the previous form. It's just to emphasize that what it already said, which is unless the parties agree otherwise, the property is being sold in its current condition, and seller may but is not required to engage in negotiations for repairs and improvements to the property. Any of you that are really familiar with this section of form know that that was already in there anyway, but it is to emphasize that in a different way to hopefully prevent you guys to have to get in arguments with either other brokers or with a buyer or seller. All right. This is some technical changes to this, and nothing substantial here. I don't think that I need to cover in any detail. This was an interesting change by the committee, in my view. There was always we always got a lot of questions on the hotline about who's responsible for what when it comes to HOA costs. All right, so there's been some changes to paragraph B here, and it says buyer shall be responsible for any loan. Okay, and then it deleted this, and then number 2, or shall I say new number 2 little I, charges by an owners association or management company as agent of the association under paragraph 9B. Okay. So right now this is paragraph 6B. When we get to paragraph 9B, well, actually let's just skip down there now and do it now. So we'll come back to 7D. Let's go to 9B. All right. So this is the seller's revised paragraph regarding these sorts of costs. And what it does is the seller is going to pay for fees incurred by the seller completing the RPODs, fees for confirming the seller's account payment for the owners association, and other fees associated with that. Any fees charged for transferring or updating ownership records, any fees other than those specified to be paid by the buyer under paragraph 9B. And here's paragraph 9B. The buyer is going to pay charges for providing information required by the buyer's lender, working capital contributions, membership fees, charges for the buyer's use of the common elements, services, and in determining restrictive covenant compliance. So as you can see, I think that there was a real effort by the committee to try and make sure that these paragraphs reflected what you guys already felt should be the case anyway. I think a lot of the hotline questions I got in this arena anyway, it was some frustration with the language not quite being precise enough so that the costs were apportioned according to who's getting the benefit. So I think this does a better job of doing that. We will see how it goes as far in real life, and we'll continue to get that feedback on the hotline and other places for that matter. Just general input from members that staff receives. We'll look at that and see if that actually accomplishes what it should. I personally, I think it's a big improvement compared to how that those obligations used to read. So fuel tank. Here's the new paragraph of fuel tank. This is paragraph 7D. So it's under the seller's representations. Okay. Now, the interesting thing that I just got a hotline question about this week too. The question was whether this should be filled out preliminarily by the buyer agent or the seller agent. Apparently, one of the vendors set it up so that the buyer couldn't even check these boxes, and instead they had to wait for the seller to do it after they received the offer. And I think hopefully we'll be able to get that fixed with that vendor, because I think that's the wrong way to go about it. Mostly because it's going to put you in a constant situation of, if there's representations that are changed by the seller, it's probably a material change to the contract that means that once the seller signs and they do these check boxes, they're sending it back to the buyer and it's a counteroffer. So then if there's some sort of oversight, and I know you guys are super busy, things happen. You're not necessarily going to catch every single thing every single time. At least I don't expect that from you anyway, because I certainly don't want someone to expect that of me. But it puts you in a situation where if the buyer doesn't initial that change by the seller, even if it's on a representation like this, then you could be performing under a contract that's not actually a contract. And then you get into murky water about whether there's been formation or not of the contract. Nobody wants to be there. So I think that you guys would continue to do what I think most of you probably already do. And that's if you're in the buyer agent position, you're going to find out this information, have the buyer fill it out on their end so that a complete offer can be sent over to the seller, and hopefully have a better chance of getting it all the way effective the first time. So this paragraph on fuel tanks, it's a representation of the fuel tank, how many fuel tanks, whether it's in use or not, whether it's owned or leased, whether it's above ground or below ground, type of fuel, general things like this. Okay. And then it gets down to little 2I here, tanks included in the sale. Buyer seller agree, any tank described above is owned by the seller shall be included in the sale. So only if it's owned by the seller, not if it's leased. And then the seller may use the fuel in tank through settlement, but may not otherwise remove the fuel or resell it. Any fuel remaining in the tank as a settlement should be part of the sale. So that was and just know that that's a big change from the way the previous paragraph wrote. Under the previous tank paragraph, the seller could resell the fuel instead of making it part of the sale. That is no longer the case, at least under the standard language. Of course, you can adjust that as necessary. And I guess while I'm on it, and just in case you don't know, I mean, let's say that you have a transaction where the seller is going to do this, and this is contemplated by the parties at the beginning. One of the things you would have to do, and there'd be a bunch of things you'd have to do, but one of the things you'd have to do would be to cross through this paragraph here, which you can do. What you cannot do with the forms is make alterations to the actual pre-printed language. So for example, you open up a PDF editor of some kind and you go through and start deleting language and inserting language as if it's part of the pre-printed language of the form itself. That is not permitted under a forms policy. But if you cross through this and then have an attorney help you with an addendum, or if your client wants to write an addendum or something like that to change the obligations of the contract, that is certainly permissible under the forms policy. So that's a question we get occasionally on the hotline is, how do you make changes to the pre-printed language? And that's at least one way you can do it. Another way you can do it is just attach an addendum that says, this and this and this don't apply. Even if it's not stricken out, you could say that the addendum controls, and then you can get to wherever you need to go doing that. All right. Let's see.
John, we had a few questions that came up in the chat.
Sure.
One was, how is this policed and how would a buyer know if a seller and did sell the fuel back? Example, if it were auto-filled by the gas company.
So here it says the buyer should be entitled to conduct inspections on anything to do with the fuel tank. So I think that's an inspection you might want to try and schedule toward the beginning. I think that would be the best way to know. You can also get a representation from the listing agent. You could ask them about it and ask them, well, what's the level of the tank right now? And I think that, the listing agent would be bound to make an accurate representation on that. I think doing those sorts of things will help you protect your client in that situation. Oh, was there anything else?
One other one that was referencing, I think, something you mentioned a little bit earlier. What about new HOA member setup fee? Is that a cost of transferring ownership paid by seller, or is it the buyer's responsibility?
So going down to paragraph 9B here, and I'm gonna bring up the chat so I can see it. New HOA member setup fee. Okay. I think that would fall under B2 here, working capital contributions, membership fees, or charges imposed for buyers' use of common elements or services. To me, it doesn't make any sense for a seller to pay for a buyer's new membership fee. If it's a new membership fee for the buyer's use and enjoyment, then I think B2 would cover that. All right.
I think one more was, can you go back to drapery and fixtures? What want to make sure she understands that.
So going back up to the fixtures paragraph in paragraph 2. Here we go. So the question is about this paragraph here. Window, door blind, shades, curtain, drapery, and rods and brackets. I'm not sure that this is a substantive change here from what was here before. It used to say curtains and drapery, rods and brackets, and now it just says curtains, drapery, and rods and brackets. Sorry. Curtain / drapery, rods and brackets. So yeah, I guess it is a substantive change. Sorry about that. And basically, instead of an argument that the curtains are to remain, it's making clear that it's just the rods and brackets. So yes. All right.
Thanks.
Let's see. I'm pretty sure we're good on 7. There's these, I'll just cover this note here. State law provides it's unlawful for any person other than the supplier of the owner of the fuel supply tank to disconnect. So if you got a seller who's, thinking that they can go out and do it on their own, no. Well, unless they're properly qualified to do it. Okay. So now we're in paragraph 8 here, seller obligations. Moving through here. 8J, owners association. This is really just, this is all going to come up later on in the paragraph we've already covered at 9, but charges by an owner association or management company under paragraph 9A. So it's really just taking all this out and making sure it gets consolidated in the proper place. There are some changes to this home warranty paragraph. I'm not sure it's anything too complicated. Just a couple different options there. We've covered 9A and B, which have to do with HOA fees. Of course, yeah, if you have any specific questions on that, the hotline's available, or you can put it in the chat. This doesn't look like a big change, but is very heavily debated during the form cycle. So, and there is a pretty important change that's coming here, and that's right here, because what it says is it uses the old language: if the property is not substantially the same or better condition at closing, reasonable wear and tear accepted. Buyer may terminate this contract and get the due diligence fee and earnest money shall be refunded to the buyer. There were some situations where, and they were coming up pretty regularly, where there'd be damage to the property while the property's under contract. And the seller would make an insurance claim, and it used to be you could just get the insurance claim and that'd be it, or a refund of your earnest money without the due diligence fee. Well, the insurance settlement offer was far, far below what the actual cost of the repair would be. And so it really was working a very unfair scenario for the buyer, where basically they're going to have to eat these costs because the seller had no obligation of the paragraph to refund the due diligence fee. And so the buyer was looking to either lose a substantial due diligence fee plus be on the hook for extra repairs, or just, lick their wounds and take the earnest money deposit and move on, or take the insufficient earnest money or insurance money. So what this does is try to put the buyer on a little bit more fair position if the property is substantially damaged, during the process. So be aware of that. And then this risk of loss section here used to be as part of paragraph 11, but it's just breaking this paragraph into two different sections. Let's see. This is paragraph 23. Paragraph 23 was added last year to clarify and consolidate, what the parties' rights are if there's a breach of the contract. And there was a little bit of change to the breach by the seller. And in the event of a material breach by the seller, buyer may either 1, elect to terminate and go through there, or 2, elect not to terminate and treat this contract as remaining full force effect and seek the remedy of specific performance. I'm not sure that's I'm not sure that that's really any different than how the old version worked, but it's just making it more clear. And I'm not sure. Yep, that is it for Form 2T. All right, so we got the big one out of the way. I think we're in good shape to finish up on time here. So moving on to paragraph or to Form 12T, most of the changes that are in this, I'm actually going to skip. You can see if you go back to the PDF, these are all the changes that we just talked about in Form 2T, but when you get to 12T, you can see there's a lot of changes that were made for the same reasons as 2T. So we're not going to go through those. However, we are going to go to this note because I'm actually pretty happy that the committee took this on and changed this, because I think the former note caused a lot of confusion and caused agents to not know whether this is the correct form or not, if there was any sort of contemplation of subdivision of land. What the statute says, and what this note is really addressing, what the statute says is that you cannot sell unpermitted parcels. So if a property is being subdivided or in the process, or let's say it's contemplated that way, the seller can't just go through and sell those parcels until they've been properly approved by whatever municipal corporation needs to do it, whether it's the county, whether it's the city, whether it's the city and the county, whatever it is. So they got to go through that process before and have that parcel be approved before they could sell it, because it's a misdemeanor if you do. So, well, I think what this note does, I don't think there's any, even though it looks, kind of serious and imposing, I think what it does is actually say what the old note said in different words, but maybe not quite as clear of words. And that is that if the buyer is looking to subdivide down the line, then that's fine if you use this contract, even if that's the buyer's intended purpose. And what it does is it talks down here about if the buyer's contemplating a subdivision as a condition of purchase, buyer should consult with an NC real estate attorney, which they should, because there's not going to be a contingency in here that if there's, if the buyer's looking, say it's a developer of some kind, they're looking to subdivide a large parcel, but they're not going to buy this property unless the county or city approves it, then you're going to want to do an addendum that makes sure that addresses that. Because otherwise there wouldn't be a contingency in here for that. However, as far as whether you can use this contract to put the entire parcel under contract, yeah, you can. And so that's really what this is getting at. And then there was a change to the note for new construction here. If the sale involves construction of a new single family dwelling, consider using 800T, or if there's construction completed, use 2T and 2A3-T. So if it's a property where it's going to be a new build, one of those is probably going to be a much better fit than trying to use this particular form. The interesting thing is, just so you know, the using the correct form is important, because it's conceivable that you could have a new build situation, use this contract 12T, and even though this contract wouldn't cover a lot of really important details that would go along with a new build, you could have the parties be under contract with essentially no real direction on who's responsible for what, when, and how as far as the new build's concerned. So those two other forms, much better fits. If you do accidentally use this form, I would say, like, say you got a new broker who does that. I think that there's an argument that you're under contract. It's just that you don't have a very effective one that does a good job of outlining the proper rights and remedies of the parties. All right, so let's form 12T. As I said, the rest of the changes that go through here, we've already substantially covered as part of Form 2T, okay? So that'll keep us moving on to the buyer possession form. This is Form 2A7. All right. So there's some warnings at the top, and there was some question as to what short-term occupancy meant as far as what the old form used to say. I'm not sure. I guess what I always told people is that, if you're looking at going over 6 months, you at least got to have a discussion with your client of whether you want to have a full-blown lease or not. But even then, I mean, this thing, you could conceivably use it for years or a year. It's going to be, in my view, a binding lease, no matter how you fill it out for whatever length of time. The reason that it's short-term occupancy is because of some limitations on this. And before, it was a little bit more important. One of the biggest limitations in the old form, which I think are addressed in this form, I'm pretty sure anyway. Yeah, here we go. We'll get to that change next. But it used to be that there's no right of entry on the part of the buyer or on the part of the seller once the possession changed. So just know that the ability to access the property, especially on the seller possession side, was very limited. The buyer couldn't get in there and do a lot of things. That's probably the biggest difference between this particular kind of lease agreement and having like a full-blown lease agreement if somebody's going to be there for a long time. But as far as what short-term occupancy means, I think the committee is correct to remove that language, because conceivably you can use this for a lot longer than short-term, as long as that's what the parties want to do and understand what the risks are. Anyway, so this form does not address important issues typically addressed in a residential lease, such as a security deposit. Consideration should be given to using a residential contract if you're going to be, if that's one of the things that you want, as well as access to the property. Because if you look at down here in paragraph 1, so, number 1 is talking about possession, as it usually does, but there's been some language added in here saying seller should not access the property during the term without buyer's written permission, except in the case of an emergency. Seller should be entitled to retain an entry key to the property, but shall deliver other means of access to the property to buyer on the commencement date. So what that means is, number 1, it's addressing the keys, which there was some confusion on when the keys need to be turned over. This makes that more clear. And also this addresses what the seller's access to the property can be while the buyer's in possession. There was previously no mention of either one of those. This is brand new language. And so I think it helps put the parties on a little bit more, I think it puts them more on the footing that they would have expected to be, if certain issues come up with the property while the buyer's in possession. Paragraph 5, there was a change made. If the contract is terminated, buyer shall immediately vacate the property and return all means of access to the seller. I think you could argue that that was required under the previous version, but something new for this one. All right. And so the seller possession form has, substantially these same changes. If you go in here, you can see for 288, the warnings are the same and the paragraph 1 changes are substantially the same. So if there's an emergency, you can get in there. It used to be that even if there's an emergency, you couldn't get in there. So that change has been made along with when the keys are to be turned over. So just be aware of those changes. There's someone asked in the chat, does it say who has access to the security camera? No, that wasn't something that was addressed by the committee. So I don't think that is in there. But I think I think it's a fair point that something should be brought up with that, because it's just becoming more and more prevalent, even on homes that are not smart homes. Almost every home has well, not every home. I would say about half the homes that I go up to now have a video camera doorbell at least. All right. Next form we're going to go through is 4T. Probably the most important part of this is actually right here at the beginning. It just gives you a little blank to say what number of amendments this is. You were always permitted to do multiple amendments to the contract. There was nothing to stop agents from doing that in the past. And all this does is, give you the ability to say what order it should be in. So here, there's been some changes as far as a successor escrow agent, and I'm trying to see. Yeah. So if there is a successor escrow agent, kind of goes through that process. And what a successor escrow agent means, if there's somebody was the escrow agent before in the contract, now it's being changed, then there you go. And just you can release the earnest money deposit to the second escrow agent, whoever that's going to be. And then gives you an acknowledgement where whoever the substitute escrow agent is going to be, the successor escrow agent, then they can sign for that here. All right. Moving on to the exclusive right to sell listing agreement. Let's go down. You can see the same changes for fixtures here that are in Form 2T. Same with fuel tank. This is going to be moved to the end. Has to do with attorney's fees if there's a breach. So changes to, there didn't need to be as many changes here with respect to tanks, because a lot of it was here already. And you could see that it was the new 2T was kind of borrowed from Form 101. But adding these paragraphs here and these two notes, these were also in 2T. And we're going to get to something that probably you guys are going to continue to have questions on even after today, but I'm going to do my best to try and make it so that you don't have questions about this. So remember, this is Form 101. This is the exclusive right to sell and listing agreement. So if you're the listing agent, this is the standard form for the listing. All right. So what we do is we start out this is a new paragraph, or it's a substantially, well, not a new paragraph, a new section on dual agency. Okay. So first we start with a new definition of designated dual agency here in paragraph D. And when a real estate firm represents both the buyer and seller in the same real estate transaction, the firm may, in its discretion, offer designated dual agency. You don't have to, but you can. Okay. And if offered, designated dual agency permits the firm with the prior express approval of both the buyer and seller to designate one or more agents to represent only the interests of the seller and a different agent to represent only the interests of the buyer, unless prohibited by law. And the most common time that designated dual agencies can be prohibited by law is if you've got a BIC who's on one side and a provisional broker on the other, because you can't have a firewall between those two because the BIC has to be over the provisional broker at all times. So I'm not even sure if I can conceive of another one. There might be another one, but that's the most common one. So in that situation, you're not going to be able to do designated dual agency. All right. And also, yeah, okay. I guess another instance would be actually the note right here that an individual agent may not be designated to represent a party if they've already received confidential information concerning the part of the transaction. Again, that's a breach of that firewall there. And I think that in order to preserve your fiduciary duty, that would be the case. All right. So what we've got here is some new initial boxes. And the purpose of these initial boxes was trying to make it more clear that you can't do designated dual agency, which that's where you authorize down here. Okay, this is the designated agency section. But you can't do designated dual agency unless the client's already authorized dual agency. So the first and important question, and I think the best way to go about filling this section out is to take it line by line. So first you got to figure out, is there going to be dual agency? All right. And if there is going to be dual agency, is the seller going to give permission for the same individual agent to represent the buyer and the seller? Okay. And depending on their answer to that, then, and what's different about this designated agency section is actually right here on the second line, where it says, in addition to authorizing firm to act as a dual agent. So up here, if they've initialed this, seller authorizes and directs firm to designate an individual agent to represent the seller and different individual agents to represent the buyer. So just understand that this is now a direction. And the reason for this was really at the urging of the Real Estate Commission, because they were having so many complaints where the seller authorized designated dual agency, but in the old form, it was up to the firm whether they wanted to do it or not. There was confusion on the part of the seller. They thought that if they, initialed that line, then that was directing the firm to do designated dual agency, and that's the only way they wanted it. But that wasn't the case, and that's not what the form actually said. It just said that that was an option if the firm chose to exercise it. This is entirely different. It is a total change. You need to be aware of it, that if you are going to allow designated dual agency and you check this paragraph, then you are also being directed by your client to do it, and the commission is going to expect that you're going to do it. If a conflict comes up where you can't do designated dual agency, let's say you have a buyer who is not authorized designated dual agency and a seller that has directed designated dual agency. If you're in that situation, you're going to have to try and resolve it with your clients one way or another. And you're going to have to recognize that that's a conflict that needs to be addressed. So after today, when you go back, talk to your agents, make sure you go through this section in some detail, do follow-up questions as necessary. But that's the way that this is formed. And again, don't shoot the messenger. This was at the urging of the Real Estate Commission. They wanted to have this done and to be able to prevent confusion on the part of the consumer. And also, I think that this is a better protection for your client. It's going to help you be on the same page with them as far as who is expecting and what is allowed, who has the choice to make one way or another as to whether there's designated dual agency. Going to the second part of this paragraph, there's a line here that says that exclusive representation, seller desires exclusive representation. That means they're not authorized in dual agency. So that means you're going to initial here if they're going to authorize dual agency and then go through these sections here, or you're just going to do this one. All right. And here you can see the old language that was there about designated option and things of that nature. That's all been taken out. All right. So similar to 2T last year, where paragraph 23 was created from different sections of the contract, it really keeps everything, it moves everything all into one spot. So paragraph A here talks about how it's a binding agreement. and the seller can withdraw from the fiduciary relationship prior to the expiration agreement, and except that it's going to be a material breach unless it's been terminated in writing by mutual consent or legally sufficient cause. And I think those were all parts of the previous version of Form 101. So if you have some old Form 101 listing agreements, just know that that language is in there anyway. I'm trying to see where the old language used to be. Yeah, here we go. It used to be down here in this paragraph, but now it is up here. All right. And here, if there's a new paragraph about breach, sellers in material breach of this agreement, firm will be entitled to pursue all remedies available, including but not limited to recovery of the fee in paragraph 7A. And this provision be in addition to firm's rights to the fee if seller breaches the agreement after the fee has been earned in accordance with 7B. Again, I'm not sure that's a big change from the previous form, but it spells it out in more detail. Mediation, if a dispute arises out of this agreement or the breach thereof, dispute cannot be settled through negotiation. The parties agree to try in good faith to settle the dispute by mediation. And just understand, if you get in a situation where you're in a dispute with a client and you're looking to go after a fee, this request to mediate is something you got to do. Or it's a checkbox you got to get through. And so I actually took over a lawsuit midway one time, started in small claims court with the listing firm, and they lost there. So we appealed it to district court. And one of the things that I had to do as part of rewriting the complaint to make sure that it actually got the correct parties and things of that nature was also make a demand on the other side to do mediation, which they declined since the lawsuit had already started. But as part of that, what I did is substitute the parties. And so basically starting a new lawsuit with a new party, made that demand for mediation ahead of time. And so when the other side started complaining about that, I was able to show the court, listen, I offered to do the mediation. They didn't want to do it. So we're here. So just understand, if they refuse to do the mediation, that doesn't mean somehow you're barred from court. They can't hold you hostage just because they don't want to do mediation. You can, you try to do it, try to work it out, try to offer the mediation. And if they're not going to do that, then you can, take the legal route, the court route. And then finally, attorney's fees under 21.2. I think most of the time there's going to be, it's a reciprocal agreement. Sometimes some judges may award all the fees, other times it may be capped. So just understand that if they are capped, it's likely going to be at 15%. But those are things that every case is different. If you're in a position where you're looking to go after a client for a significant fee that you would have got for a breach of a listing agreement, there may be other options to you to get attorney's fees that are not capped. So make sure you go through that with your attorney. Renee says, explain how the seller can end the fiduciary relationship, yet the agreement still stands. And that's simply the law of agency. Just because you sign an agency agreement with somebody, if you don't want someone to be your agent anymore, you can withdraw that permission. It doesn't change the fact that you still have made an agreement and that you're liable for the fee that is in that agreement. But as far as whether someone has to be forced to have a particular agent, the answer is no. And the law is not going to impose that. So that's why the seller can walk away at any point from the listing agreement, but that they may well be breaching this agreement, and that would mean the listing firm's entitled to the fee. All right. And again, if you go over, that's Form 101, the exclusive right to sell listing agreement. And you can see here's the bullet points on that. And then if you go down to Form 201, which is the buyer agency agreement, it is substantially the same as Form 101. I don't think there's anything in there that we need to cover today, especially to give you guys a little bit more time for a Q&A. We're doing good on time, so I want to make sure that we stick with that. Finally, we get to Form 780. So let me go there. And if you're not using this form, you really should consider it. It's something that you can send to your client, and it just gives an overview of the contract. If you're in the process, that you can go through that. There's a lot of really important information in here, but one of the big changes that was made to this is explaining when the due diligence fee is due and payable, and really going through what the contract says. It also makes it clear that the buyer's right to terminate for any reason or no reason is dependent on making sure that's paid. Also, another important change is really stressing here that in an event by a material breach by the seller, recovery of the due diligence fee may be time consuming and costly if the seller does not voluntarily refund it. So just really stressing that it's non-refundable, but even in those situations where it could be refundable, it might be hard to get it. These are important things that your client needs to know. So if you're not handing this out to your clients to look at as they go through the process, you should definitely consider it. Those are the only big changes to this particular form. I think that they were valuable, but just be aware of those. All right, that's hitting the highlights of pretty much everything. Holly Pierce. One of the Holly Pierces asks, why did you remove including the pamphlet on inspections from the buyer agency agreement? I'm pretty sure it's because that agreement doesn't exist anymore. So I think that's why it's not in there, but I'd have to double check that as far as the committee notes. Let's see here. Where was... Give me just a minute here. I'm going to find that. Make sure I'm correct. Sorry, I was in the wrong form there. There we go. Where was that? What form was that in? All right. Yeah, I thought it was in the listing agreement. Let me go find. Go back to that. Here we go. So paragraph 14. So we go over here to 101. It's down below here. There we go. Form 101, paragraph 14. What it says is that it was stricken. Instead of a checkbox, a new note's been added at the end of paragraph 20, refers to the seller to the entire series of Q&A brochures on real estate transactions available on the commission's website. So it's really just to give the client more resources than what they otherwise were doing the checkbox to be given. All right. No problem. Any other questions? If not, you know how to bug us.
John, do you mind re-putting the stuff you shared at the beginning in the chat on just how to contact anybody if they have questions? The email, I think there was an email and a phone number also.
Yep. There you go.
Great. Well, did anyone else have any other questions?
I put everyone to sleep. No questions.
all important information. Well, thank you for joining us, John, and thanks everyone. If reach out if y'all do think of anything. I'm sure some things will come up, but I hope everyone has a great day.
Y'all take care. Thanks for having me.
All right, thanks everyone. We're gonna close this out.